Another likely First Amendment case before the court this term is ACLU versus Mukasey, the latest round of litigation in the saga over the Federal Child Online Protection Act, or COPA for all you Barry Manilow fans. COPA is Congress's second attempt to impose severe civil and criminal penalties on the display of constitutionally protected, non-obscene speech about sex on the internet. COPA criminalizes any speech on the World Wide Web that is, quote, harmful to minors, if that speech is, quote, available to any minor. After 2 decisions in the Supreme Court concerning the statute, the lower courts concluded that COPA was unconstitutional, censoring too much speech that adults could otherwise access on the internet when there are less restrictive alternatives, particularly content blocking or filtering software. The US government has not yet filed a petition for review in the Supreme Court, but it's expected to, and it's very likely that the court will take up that important ACLU case. A third First Amendment case on the docket this term, one the court has granted review in, comes from the 10th Circuit Court of Appeals, and it's the latest Ten Commandments dispute to occupy the justice's attention. Here, the issue is whether Pleasant Grove City, Utah's decision to display permanently an unattended, privately donated Ten Commandments monument in its city park required the city to provide equal treatment to a similarly sized religious monument offered to the city by adherents of the Summum religious faith. The Court of Appeals held that it did, because the city had made the park a so-called public forum where the strongest constitutional neutrality obligations apply. The 10th Circuit concluded that the city was discriminating on the basis of the viewpoint of the speech involved. They liked the majority viewpoint of the Ten Commandments. The city, supported by the federal government, is arguing that this monument is actually government speech and not subject to viewpoint or content neutrality requirements. Usually, cases like this involving display of the Ten Commandments present Establishment Clause issues on the ban on laws respecting an establishment of religion, which is normally what we would have seen, but that's not the way this case is coming before the Supreme Court. It's only coming about viewpoint neutrality under the Free Speech Clause of the First Amendment. It's possible that Summum wanted to avoid the uncertainties of the Establishment Clause argument, because the last time the court took up the Ten Commandments, just 3 years ago, it split badly, 5-4, in 2 different cases, one that upheld the display, one that struck it down, with the 9 justices issuing 10 separate opinions. This case will be argued on Wednesday, November 12th. The Supreme Court is also hearing lots of cases about rules governing procedure in criminal cases and the constitutional constraints on law enforcement officers. It's granted review in a number of cases concerning the Fourth Amendment's ban on unreasonable searches and seizures, including the issue of the applicability of the so-called exclusionary rule that keeps prosecutors from relying on evidence obtained through Fourth Amendment violations, unless the case falls into an increasing number of exceptions to the rule that the court has crafted in recent years. The Supreme Court has also granted review in a number of cases concerning the ability of convicted persons to challenge the constitutionality of their convictions via habeas corpus. In the interest of time, though, I'm just going to mention one constitutional criminal procedure case, Melendez-Diaz versus Massachusetts. This dispute revolves around the Confrontation Clause of the Sixth Amendment. That clause gives criminal defendants a constitutional right to cross-examine witnesses against them. In recent years, the Supreme Court, led by Justice Scalia in some of his more literalist moments, has relied on that clause to insist, for example, that defendants even have the right to cross-examine child witnesses they're alleged to have molested, who might understandably be very traumatized by having to face that. Here, the question is whether defendants have a right to cross-examine at trial a forensic expert who prepared a drug lab report that was used by the prosecution as evidence against him. The Massachusetts High Court thought that the drug lab report was not, quote, testimonial evidence that would implicate the Confrontation Clause, and therefore it upheld Melendez-Diaz's conviction. The fact that the court granted review in this case has alarmed prosecutors around the country, as the decision has the potentially dramatic ability to change how criminal trials are conducted in every state of the Union. This case is going to be heard on Monday, November 10th. The Supreme Court is also going to hear a number of civil rights cases this term, including one, Bartlett versus Strickland, on whether a racial minority group that makes up less than 50% of a proposed legislative district can make out a claim that their voting power has been diluted in violation of Section 2 of the Voting Rights Act. The lower court said it couldn't, and this is a case that could have dramatic implications due to the importance of coalition districts where minority groups may be less than a majority but might be able to band together to elect their preferred candidates. Last Wednesday, the court heard argument in a sex discrimination case, one of several this term, Crawford versus Metropolitan Government of Nashville and Davidson County, Tennessee, or Metro. The Crawford case arose when the Metro School District started investigating a case of alleged sexual harassment by its employee relations director. Metro School District employee Vicki Crawford cooperated with the investigation and gave what she characterized as testimony against the director, despite her expressed worries that she might lose her job for doing this. And in fact, within months, Crawford, as well as the two women who had filed the complaints of harassment against the director, were all fired. Crawford sued under Section 704A of Title VII of the Civil Rights Act of 1964, our federal employment discrimination law that, among other things, prohibits harassment on the basis of race or sex. The question is whether this anti-retaliation provision of Title VII protects employees who participate in an internal employment investigation of alleged sexual harassment. The Sixth Circuit Court of Appeals, yet another of our conservative courts of appeals after many years of judicial appointments, said that it did not cover this. And the Supreme Court granted Vicki Crawford's petition for review, which, fortunately, in my view, has been supported by the federal government. Now, joining with various other civil rights groups, the ACLU filed an amicus brief, a friend of the court brief in this case, arguing that failing to protect employees in these circumstances would make it even harder to correct what is already a pervasive and underreported problem of sexual harassment in the workplace. Now, this past May of 2008, in a case involving Cracker Barrel Restaurant, the Supreme Court held that a different federal law that banned race discrimination, 42 United States Code Section 1981, did protect against retaliation for bringing claims of discrimination. So there's at least a little cause for optimism that the Supreme Court will reverse the lower court in this case and find Vicki Crawford and people like her protected when they cooperate with the internal investigations that are so important for employers to avoid liability for sexual harassment. Another sex discrimination case that the court's deciding this term is Fitzgerald versus Barnstable Schools Committee. This case deals with the interaction of two federal laws. One, 42 United States Code Section 1983, which is the general federal statute used to bring constitutional suits of all kinds against state and local government actors. The other is Title IX of the Education Amendments of 1972, which generally prohibits sex discrimination in federally funded schools. Jacqueline Fitzgerald was a kindergarten student in the Barnstable School District, allegedly repeatedly sexually harassed by a third-grade boy who did such things as, on the school bus, forced her to lift up her skirt and pull down her panties and spread her legs. Her parents complained repeatedly to the school district, which they did not think treated her complaints fairly and evenly, and they weren't satisfied with the few steps that they offered to correct the problem. So they filed suit because of what they felt was sex discrimination. Now, even though Title IX doesn't have an express cause of action that says that plaintiffs can sue under it for violations, as opposed to empowering the federal government to take away federal funding, the courts have implied a private cause of action. The First Circuit, though, has held that Congress intended that act, Title IX, to preclude people like Jacqueline Fitzgerald from raising a suit directly under Section 1983, arguing that her constitutional equal protection rights have been violated. The Equal Protection Clause and Title IX have different scopes of coverage and different sorts of remedies available, so this is a really important decision. Oral argument in the case is going to be held the first week of December on Tuesday the 2nd.